all that stuff and adding it to there, it it comes out a lot better, and they stay moist.
It's probably better. So.
Let's see.
Wait.
What's it like down here?
I haven't been back there yet, but I would have no doubts it's warmer back there for some reason.
Well, that's why I got my door open, just to try, because everybody says it's so hot in here, so I.
Warmer back there?
see it. Yeah, there's chicken and then there's still just a little bit of beans left, there's some mac and cheese in there, there's, whatever you find. There's a couple ribs, there's chicken from my sister's, there's chicken from yesterday. And, you know, if you want chips or whatever you find. There's lettuce, I don't know. There's lots of corn, so I'm throwing it out. In the microwave. Throw the corn. They did a nice big corn chip. I was told all about it. Yeah, got that, and her hugging her new stepping stool in the bathroom. She's like, this is bugging on it. Her stepping stool over there. Jeez. But. She loves the, she wants to do it more than once a day. She's like, that's enough, May. Yeah, she wants to do that. Which is a good thing.
around this desk with the TV and first chair on your left there.
Thank you.
Mhm. Okay, turn, scoot it on one. Oops. Did something happen this morning that, the schedule is so bare? I thought it was gonna be packed all day.
Not that I know of.
Alright.
Not that I know of.
Who else is 95 this week, this month?
Who else is? What are you roving?
I guess,
Are you supposed to be the rover or
I guess.
just you, me, and you and me?
There'd be somebody else.
Is there two or three?
What?
Is there two of us or three of us that are 95? I don't remember. I think it's just two.
So you're 95 for the month,
Yeah,
you and I.
yeah. I follow.
Okay.
I follow you. You were just 9 to 5, right?
Yeah,
Of course. Yeah.
so. So you'll be 95 next month as well, okay. But next week, I believe it's next week, Leonello is on vacation,
Oh, is he?
so that means one of us will be doing paper.
Papers.
I kinda like it when Bill's up, I mean, not because he's away, but.
Yeah.
you
It's
kinda
nice
get-
getting out.
Huh?
What'd you say? I was gonna say it's nice getting
You're
out.
on your own and you just
Do your
grab a
thing.
bunch of envelopes and you pick your route and you get them done.
Mm-hmm. Yeah.
Stop for lunch wherever you want.
I mean, you're basically a road car.
Yeah. But I can't wait to return. So many things in life. earbuds,
AirPods?
earbuds,
For what? For this?
for music, just for
Yeah.
this, huh?
Hmm?
Wireless Bluetooth,
I have ones that are JBLs that are just buds and then just a wire, you know, going to each other. And then they're Bluetooth, and then just some Beats Studios, big earmuffs.
our radios here have Bluetooth capability.
Really?
With Patrick's help, I had my radio in search mode for
Mhm.
Bluetooth item, and I had my earbuds next.
Yeah.
And there's a little button that you push for it to connect. So I pushed the button on the back of the AirPod, and it appeared on the radio.
Oh shit.
When I selected it, it said not authorized.
Oh really?
So, which means it sends their AirPods, but we're locked out of making any of those changes. So we can't accept it. So I went over and talked to Owen Friday about it. And he didn't like the idea of earbuds because they would so easily fall out.
Mm-hmm.
He would say, he would entertain the idea of the ones that kind of wrap around
Mm-hmm.
and go in your ear, so they're a little more stable and permanent.
Right.
Well, you know how they say your phones and your stuff are always listening? So now I start getting these videos and commercials for these waterproof black wraparound earbuds.
So we're not gonna go.
Wrap around.
Just
we're
like
gonna
you
do
described.
another free trial.
But wouldn't that be nice to be able to have
That
that?
will across.
I can't stand that wire and all that stuff.
The whole off on
And
doing.
Those ones that we have,
Because we're gonna do.
after a while, my ear canal starts to itch because it's warm. I take it off.
And.
Now with those earbuds.
All of that. Okay,
That'd be nice.
alright, it's good for you.
No, it works like
No
that.
promises, only
For
because,
Bluetooth.
well, first of all, like, we never give promises. I think it's, and normally I feel a little reluctant to advise too proper, in this
We
case.
just,
I don't think the proper adds to that is something. Definitely help. And it's completely consistent with everything that you've been saying and doing so far, that a lot of people remain consistent on the right track.
yeah,
You're not new, to the systems and assuming that you're aware of all the risks that come along with the property.
I think you're right.
I imagine that you read those before you ever decided to say a word to law enforcement about it. If you have questions, I'm sure that you'll get off and answer them, but.
Well, I got this ad on my phone, it was from, it sounded ridiculous, but the earbud, they call them earphones because they wrap around, as opposed to an earbud, just goes in the ear. Technical terminology. So these earphones are called transformers. Like Megatron. And it's a neat little commercial, but you know, it is what it is, because you gotta test the product and research it. But it was normally $59.99, they were down, marked down to $7.
Amazing.
I think the company is called Transformers, because I went on Amazon and I tried to find it for Amazon, and they don't have that particular model. They have other models of Transformers. Some of them are in yellow, some of them in white, most of them in black.
So,
But I would like to get a little group of us kind of researching it and trying to find
one thing that.
the best one for the lowest price. And so they'll go for it.
They are very distinct in your case. You're keeping them distinct. Now.
Now, do you have Apple earbuds?
To this county.
No,
And over 5 years,
newer
so
generation.
they're not gonna lose it.
The ones that I have now, I think they're second generation.
Do you know what city?
They're not cheap. They're around $200. But the stem, you can touch, and the stem has different functions. You know, mute the radio, the sound, whatever you listen to. It'll turn them on so that I can talk to you and hear you normally. And then, I can just simply turn them off, but I can answer my phone with it
And before we do.
and do all these things because it's just a tap. And, phones, yeah, but I still don't like the idea because that little piece can fall out and then. Well, you still have your. But, he goes, I like the ones that wrap around, I'm like, okay. I'll
Did
check
you
them out,
have
see
like
what
a
it is.
dash camera?
And they're black, and they're black.
Recorded in an SD card? That's the other reason, so he said that there are like 3 different types of things on the SD card. One is the the other is what looks like kind of an average adult.
But they gotta unlock the radio
Filming
to allow that
themselves
Bluetooth
watching
device.
porn. And yeah, he didn't
I mean,
suggest that
when
that
you
would
do
be,
search,
I'm
it
wondering
brings
if,
a whole
I'm
list of
hoping it's due because that'll
unknown sources of
create a
Bluetooth
connection
signals.
there. And then
Mhm.
the third thing was.
Yeah, I can talk with my
They
earbuds.
thought it was you, but said that there's video. It looks like one of those aftermarket dash cams that you can get. And driving all over.
Yeah,
It's not me, nothing on that.
Nothing,
Or
okay,
you might
and that's
just have
part of why I
a piece
wanna
that you
see it
just
first, so
touch.
then I
Yeah,
can
just
look at it and I
nothing,
can call the prosecutor and be like, I've looked at them face to face in the jail. Looked and
Yeah, it's
looked
out
at the
there. We
video,
just
it's
gotta
not
find
going
it.
on. Alright, so right now,
So it was a
part of
source
their
called
confusion.
Tom Mountain, COMM, then Mountain. I guess it stands for communication.
And
But I didn't have a chance to go into it, but that's supposed to have police,
But there's
devices, or devices made for police ones.
images of you are saved to that SD card, you know, okay. It was to see it on Friday, but I have the release. This is a medical release.
Okay.
Um,
They came and got me for medical, I signed up with them, like, good.
this one's for me.
Okay, cool.
And it's for me to sign there.
Right here.
Yeah.
No, it's-
More than that.
I don't say one.
A little thick in the arms and the chest.
And then, just so you know, this isn't completely filled out yet, I will be filling this part out, I'm not pulling a fast one on you. I just wanna, if Lake Erie has a contract with like Metro for the clinic or whatever, I'm actually requesting information from Metro or the clinic, not Lake Erie. But I'm gonna have to do that first.
Friday, I went out to Lake Erie Correctional.
Any questions?
I do,
I started, I left here about 9:30. Got up there about 10:30.
I've been sleeping a little bit,
I
like,
got there 10 minutes.
a lot is going on in my mind. I just don't, I like you.
Yeah, but my guy was in medical to be cleared that day for the police. He wouldn't be in medical before the count started. Even though I was 10 minutes early, I had to wait for that 10 minutes, and I had to wait for the count. And then I was finally let in. And then it just seemed like that one assignment took at least 4 hours. To go out there one time. Dottie was nice enough to do that. The rest was not about me. So I just had to go back and, yeah. It started, the computer thing started to flow out easy. Yeah. Well, when I worked the desk, I worked at Chick-fil-A. I I said, tell the guy, I said, we looked at the restaurant, because I wanted to do them a lot, I wanted to get proficient. So, but now, I can't remember how many months ago it was that I was doing that. And now we have somebody else doing the restaurant, I had to do them by myself. But now, I probably could get through it, it would take 2 minutes.
Yeah. I feel like sometimes the only stage part of me is putting in the card.
You and I got, yeah, that's the one thing you only have to do that in the restaurant.
Well, seeing it
You and I
all
got that.
online, or I can put in the cards.
I thought it was a legitimate, and I'm like, yes.
So that, well, the only reason I did it was like because food, so like I was doing all the food, and I wasn't so messed up on.
And the thing I don't know is where they say, like, assisting officer.
Kind of gave me the heads up
Well,
on it, that is showing to be true, going to
Like, for example, I think, I had to go out to Medina.
They call us, right,
County jail.
and that may be something that we have to live with at the end,
So-
because we may not get through that.
I don't have there's no
Like, you're aware.
drop-down list
that
for,
it exists, and
Yeah,
how we got there,
sure.
and do what we can with it.
so, but if you put in the address, then it comes up, but it doesn't come up. You know, it should have all 88 counties, that should be in the list. So when you go to jail, the county jail, you know,
What I know.
this is around this afternoon, trouble.
Do you just want me to do that, and then you can bring them, alright, then,
Yeah, but the thing I kept, noticing is that, when you arrest somebody on a juvenile warrant for, failure to pay, child support, those numbers are not in the selection. Even though it's on the warrant, the CO can't find it, so he's gonna change it to FTA. And it's not really, it is, but it's not, it's more specific than that.
A buddy of mine, before I left the kid, just like he gets out.
that is it's hard to call it a silver lining, but if we brought you in on this early.
There's a lot of little things I would like to see improve.
That matters.
I was talking to
Nothing like
Mike Lee about.
watching the calendar for close to a decade, if you can get now, and then just get one shift. I mean, I've had guys get
How you been, Robert?
Not bad. Talk to me. He gave me, I signed, he said they had charges for. I signed. Is that when this thing started? He said it started.
Yeah, I think it was about, transports. There's so many things get thrown into transports, like, when you follow the spot out to they're technically doing the transport.
Right.
And then the guiding person, and then bring you back, yeah, that's a transport. That should be more like assist fire.
So there's probably a probable cause.
I mean, there's things,
At the time.
things that could be more specific, but he says. So it really matters? Yeah.
Oh,
Yes, when you're looking at that.
You say there.
I mean, if it's coming from Bowen, it's one
Yeah,
thing,
because-
if it's coming from Rio, it's like.
I mean, they're in but count for, if we,
Yeah.
25 bulk amount is 3, they don't even have bulk amounts for the indictment, when you just look at the last report next to it, where there's some other stuff that was there. Why they did that, I have no idea, that's not normal at this stage. He's asking Narcan, that's another thing, we'll talk to the prosecutor about.
All set? All right, Rick, it's this way.
You too, Counselor.
Thanks.
I'm gonna run downstairs. Unless I gotta wait in line.
Yes.
Judge would like to see you.
Okay.
he would give me the chance to do the treatment, and so I can change my life for the better.
All right, I'm gonna continue, community control. You're gonna serve, 78 days in jail with credit for 58. When a spot is available and we're able to do transport, then you'll be transported to the, Northern Ohio Recovery Association. You'll complete that program and follow all those recommendations. And if there are days remaining, they will be suspended. So as soon as we're able to arrange transport, that's when you're gonna leave the jail and go there. But you're to complete the program. And whatever recommendations they make as a result of the program, you're gonna follow. That's also an order. You understand that?
Yes, Your Honor.
In addition, all the terms I've given you before remain in effect. No drugs or alcohol with screens, 5 AAs a week with a sponsor, full employment, valid driver's license, utilization of only one doctor, one dentist, and one pharmacy for medication. Take your medication as prescribed and sign releases, and pay the costs and fees. Ms. Crook, any other terms?
No, Your Honor.
You understand the terms?
Yes, Your Honor.
If you don't follow them, you'll go to prison. If you don't do the program, you'll go to prison.
Yes, Your Honor.
So despite your thought process that you don't really have a problem that you can't yourself solve, you do and you can't, okay? So try it a different way than what you've been doing for the last 6 years. Anything else, Mr. Feldman?
Don't believe so, Your Honor. Thank you.
All right. Give you 90 days of credit for 85, transport you to the Cuyahoga County CBCF directly from the jail for you to complete that program and follow the recommendations. No drugs or alcohol with screens, get your GED, get a valid license, get full employment, pay the costs and fees. And I presumed we were done at that point until the Mr. Watson received or I found out from the jail that there was a hold out of Trumbull for the NeoCap situation, when that all went to hell. And the geniuses at the Ohio Parole Authority. And I asked Mr. Watson and Mr. Tompkins to find out what they could find out. The word I got is the Trumbull thing would be cleared, no problem. Then I found out through contact with Mr. Watson that the parole board was a problem. So would you like to tell me what that problem was that you found out, Mr. Watson?
Thank you, Your Honor. May it please the court. After our last hearing here last Thursday, I was informed by Ms. Rachel Criddle, the parole officer for Mr. Hubbard, that she intended on violating him for a PRC violation. In further communication with her, I had several phone calls with her that day, as well as my client contacted her through the jail phone. But Ms. Criddle had informed me that due to the fact that Jaden was discharged negatively, that he was kicked out of, from their perspective, from NeoCap, they were going to violate him for that reason. And also, I had disputed that, Your Honor. My client has disputed that, but we're past that with this court. But even if that weren't an issue, Ms. Criddle had informed me that their policy with the parole authority is that they do not allow their inmates, their clients, to go to the CBCF, the Cuyahoga-based correctional facility. And the mere fact that this court was going to transfer Jaden.
Did they explain why it matters which CBCF you go to in which county? Aren't they theoretically every single one of them designed to divert people from prison? Isn't that what they're for?
I would wholeheartedly agree with the court.
Do the parole officers understand that?
I don't believe so, Your Honor. I had to practically beg Ms. Criddle and explain just what the court is explaining, that even if Jaden didn't complete NeoCap, that the CBCF is essentially the same or similar program, that it was a lockdown facility, that he was going to have to do certain tasks there, hopefully get some skills, and come out of there, hopefully a better person. But that fell on deaf ears, Your Honor. I tried. And I can tell the court, again, that my client, and he could shed some more light on this directly, Your Honor, but in the jail, while I was with my client called Ms. Criddle, explained his side of the story. Ms. Criddle said that it wasn't up to her, it was up to her supervisor. She provided his name and phone number to my client, who had to wait because he was unavailable, but later on that day, I want to say approximately 2 p.m. on Thursday, my client called Rachel Criddle's supervisor directly and spoke to him. And it's my understanding that his statement, his philosophy, his belief was that he was going to violate Jaden, and that Jaden complete his case to the parole board, and that he wasn't concerned about whether he was kicked out or not of NeoCap, and the fact that he was going to the CBCF, that they didn't want him to go, Your Honor. So again, I wholeheartedly agree with the court, but that was, and as of 3 p.m., I spoke to Ms. Criddle one last time, who did confirm to me that they were violating him and that she was scheduled to pick up Jaden Hubbard that next morning, which would have been Friday, I believe the 29th, Your Honor. So, Your Honor, I again agree with the court, but they were going to violate him, and according to my client, he believes he has 7 months hanging over his head through a parole violation, Your Honor.
So where he stands right now is the, count one's the F3, 9 up to 36 months. The F4 failed to comply, and the F4 receiving stolen property, right?
That is
Those are the
correct, Your
three,
Honor.
and there has to be a consecutive sentence because of the failure to comply F3, correct?
That is my understanding of the sentencing
Right.
guidelines, Your Honor, correct.
Okay. Mr. Hubbard, who was the supervisor you spoke to? Do you remember his name?
Mr. Falacio, I'm sorry, Falacio. It's a funny name. I can't pronounce it, sir, Your Honor.
Okay. When you were on parole, who was your parole officer?
Miss Rachel Criddle.
And how often did you see her?
4 times a month.
Where at, usually?
Anywhere she wants me to come to. My last one was at a police station.
And what were they having you do? What rules did they have you follow?
I was to get a job and not smoke or drink, take screens, and that's it.
Did you
And
take the screens?
yes, Your Honor, I did.
Were they positive or negative?
I wasn't doing any drugs or anything like that, so they was negative.
Okay.
She told me my last visit, she had me come to the police station because a lot of people would get scared and run thinking that they was gonna get in trouble. So she wanted to test me. It was like 10 o'clock, 9 o'clock. I was doing everything. Ms. Rachel Criddle was actually not as bad. It surprised me that she did this, but she was very like understanding, and we texted all the time. I sent her messages and screenshots of my job applications and other things like hospital appointments and things just to show her that I was on a track, on a path that I would like to be on, and it just everything was all right. Like she was help. She sending me other jobs that I can apply to and everything. So this really shocked me.
Did you get a sanction when you got this charge originally?
Yes.
What did you get?
NeoCap.
No, that's what I did to you, but what did they just?
She said that originally she told me anything that you allowed me to go to, she will be okay with it unless you just try to let me out on probation. She said anything else that you would have did, she would have been okay with. But so the sanction was she was okay with NeoCap.
All right. Mr. Watts, anything else you want to say?
Just that, Your Honor, my client is still very focused and very determined to turn his life around, regardless of what's gonna transpire here. He's told me that at some point, if this court will consider allowing him to go to the CBCF, he's still looking forward to it. He would still do whatever's required of him. He wants to obtain his GED. He wants to be able to get out and get a job. He's already told me goals. He wants to get an apartment. He wants to get a car. He wants to get a job. I mean, you know, he does have goals, Your Honor. And I've spoken to the CBCF about everything that's transpired last week. And although they were disappointed because they had everything ready, they also stated that he's welcome there, that Jaden's welcome there in the future. However, he may need to be reassessed depending on the time frame that we're talking about. But that door is still technically open. I'm going to respectfully ask the court, and resentencing Mr. Hubbard here, to terminate his PRC and to consider a minimum sentence, Your Honor, on this case. Mr. Jaden Hubbard knows that he's ultimately going to be going to prison. It's my hope the court at some point in the future will consider a judicial release, but Your Honor, I'm going to ask that the court terminate his PRC and again impose a minimum sentence, Your Honor. Thank you.
Thank you. Hey, Bob, would you go tell the people from the parole authority that are out in the hallway to come in? Okay. I'll wait for you to come back when they come in. Jaden?
Whenever you ready to speak, can I say one thing too?
Yeah, hold on. I want to get these guys in here first.
And is suspected.
What?
And is suspected they're not there.
There's nobody out there?
Nope.
Nobody from the parole authorities here?
Nobody from the parole authority is here, sir, Judge.
Oh, that's a shock. Go ahead, Mr. Hubbard.
Your Honor, I just want to ask you mercifully the same thing as my lawyer to please consider the minimum, because I'm still ready. I'm still ready and motivated. I hope that you can have faith in me, because my little brother, he ready for me to come home. He has a car, and he like, I'm gonna take you to every job application, and you can live with me and everything, like, cause he understand where my mind is. I'm just ready to get past this stage in my life. I'm ready to show everybody who doubted me, people who didn't doubt me, the APA. I'm ready to show everybody that I could be a better person. Like, this ain't who I am, and this is not who I'm going to be. Like you said, Your Honor, I'm ready to put that distance between my past and who I am and who I can be. And if you please give me the minimum, you won't regret it at all. The next time you see me, it'll be all smiles. And I just mercifully ask you to please consider it, because if my lawyer was able to place the judicial and I come home and go to the CBCF, I'm still gonna get my GED. My plan ain't changed a bit, not one. I'm ready, Your Honor. That's it. Thank you.
All right. I've gone back and looked at the pre-sentence report, since really, in essence, last Thursday never happened as far as a sentence. So I looked at the PSR, listened to Mr. Hubbard and Mr. Watson, considered all provisions in 29, 29, 11, 12, and 13. So I'm going to terminate your community control on count 1. I'm going to sentence you to 9 months in prison, credit for 263 days. Count lesser included of 2, 6 months in prison. Count 3, 6 months in prison. Those will run concurrent to each other, but consecutive to count 1 by statute. I'm going to terminate your post-release control. You're going to pay the costs. So what this amounts to, we had a pretty good plan in place last Thursday that the Department of Corrections completely screwed up, which is kind of what they do on like a daily basis, is screw things up. I can't, Bob, can you look on your camera again to see if they're really not here?
Really not here.
They're really not here. Which is perfect, because they don't really perform any legitimate function. They are, besides, the Department of Corrections is in charge of the prisons. And almost every prisoner that I've talked to has been to prison. I don't know if you know this, Mr. Wheeler, but they universally say that they can get any drug they want in prison.
I've heard the same thing, sir.
And I suspect the reason is because they're not too upset about that, because that controls the population. That's my theory. Otherwise, they wouldn't let drugs in prison. But then, when they're in charge of supervising people on parole, they almost universally do a lousy job. Don't do anything. I mean, I'm surprised you had to report actually in person, because most people just have to call in once every 3 months and promise they're not doing anything bad. That's the extent of that lousy organization under the supervision of the Department of Corrections. So, Mr. Hubbard, my intention is to do exactly what I was going to do last Thursday. Of course, that all depends on your cooperation, right?
Yes, Your Honor.
Mr. Tompkins, is there anything else?
I don't believe so, Your Honor.
Mr. Watson?
No, Your Honor.
All right, I'll see you again, Mr. Hubbard.
Thank you, Your Honor.
All right.
That being possession of cocaine, a felony of the fifth degree, aggravated possession of drugs, a felony of the fifth degree, both in violation of 292511, and count 3, illegal conveyance of drugs of abuse onto the grounds of a specified government facility, that being a felony of the third degree in violation of 2921.36A2. We were last here on October 16th of 2020, and the defendant failed to appear for his hearing at that time. A warrant was issued. The defendant has been apprehended. He is here today for purposes of the pretrial. And on behalf of the state of Ohio, we have provided the offer at this point in time now due to the failure to appear for that period of time. It is a plea to the indictment. We would ask for a pre-sentence report and investigation and drug and alcohol evaluation. Defendant is present with his counsel, Ms. Nicole Novotny.
Thank you, Ms. Novotny.
Yes, Your Honor, I have received that offer. I was minutes before the hearing going over that with my client as well.
All right, I'm going to set this case for a jury trial, September 30th at 8 o'clock. We'll have another hearing that'll be September 18th at 9:45. If there's going to be a plea entered, it will be done at that hearing. Anything else, Ms. Linden?
No, Your Honor, thank you.
Ms. Novotny?
Can you repeat that last hearing when the change of plea would need to go? Your Honor?
9:18 at 9:45.
Thank you.
All right, we're adjourned.
Thank you.
talk for a second?
We don't have the other talk, 1:30.
Yes, thank you, Your Honor.
All right. Ms. Blake?
Your Honor, to start the hearing, I just want to put on the record, the court had offered the opportunity to the defendant to accept any offers in this case that had been presented. The state has presented an offer in this case to the defendant to plead to count 1 and plead to count 7. The state of Ohio had recommended, or at least expects recommending, a community control sentence if the defendant had wished to accept that offer. It is the state's understanding at this point that the defendant has rejected that offer, and that we would proceed at this point with the motion hearings. Again, a motion to determine admissibility of evidence and a motion regarding other acts evidence. If that's the intention today here, Your Honor, the state is inclined to proceed first on the motion to determine admissibility of evidence, depending on any preference the court may have.
All right, Mr. Fatica?
Good afternoon, Your Honor. I've discussed this matter with Ms. Jurnisek. She's maintaining her innocence, and she's declining to accept the state's plea offer at this time.
All right, is that correct, Ms. Jurnisek?
Yes, Your Honor.
All right, do you understand what the offer is?
I would like to maybe hear it from you, Your Honor.
Well, if you plead guilty to count 1, theft of drugs of felony 4, and count 7, illegal processing of drug documents of felony 4, then at the time of sentencing, the state will dismiss the remaining 7 counts and make a recommendation pending a pre-sentence report of a community control sanction as far as a penalty. So that's what the offer is.
And what does that mean?
What does what mean?
Community control.
Well, there's on the felonies of the 4th degree, on each sentence, there's a maximum prison sentence on each one of 18 months in prison, okay? Or since they're, so I could, the most I could give you is a prison sentence of 18 months plus 18 months, 18 month for each count consecutive, okay? They're felonies of the 4th degree, so there's a presumption that you should be placed on community control, okay? Community control is otherwise known as probation, okay? So I think what the prosecutor said is they would, if you pled to counts 1 and 7, then their recommendation would be a community control, place you on community control instead of asking me to send you to prison. So that's what their offer is. Do you understand that?
I do.
Okay.
May I address the court about something?
Okay, first of all, I want to find out if are you in fact rejecting that offer?
Yes, sir.
Okay.
Yes, Your Honor.
All right, then what do you have to say?
I had wrote you a letter over a week ago that I gave to my public defender, and I just asked him, and he said he still has not given it to you. I also had family letters that were sent to him that he's saying he didn't receive, but we have receipts that they were sent. I've asked for a motion for dismissal on a Brady violation that has occurred now twice in the pretrial of missing 4 days of missing legal nursing documentations, including the days that are in question of the 11th and the 12th of September of 2023. And I am requesting for my public defender, John Fatica, to be dismissed from my case. Sorry, Your Honor. I need my glasses. To be dismissed from my case for misrepresenting of counsel on my behalf. He has continuously failed to acknowledge my concerns regarding the defense to my case and has conducted himself in an unethical manner, calling me dumb, airheaded, effing stupid, and retarded, which I can assure you I am not any of the above. I ask to be appointed a new counsel due to this matter. I ask if you will consider reinstating my personal bond due to Mr. Fatica giving me my eyewitness, who I thought was my eyewitness, and he said I didn't have one, his first and last name and address, and told me I didn't have a witness, and then had me put in jail for a week because I broke bond of finding a witness. He said I did not have a witness, and he is the one who gave me that information of his address and last name. I wanted to know if I could have a new appointed counsel due to this matter. I ask if you will consider reinstating my personal bond so I can possibly hire representation on my behalf for my constitutional rights to have a fair trial. And he is aware of this, because we spoke of this yesterday.
Tika?
Your Honor, first, I never swore at Ms. Jurnasak. We did have some harsh conversations because explaining things wasn't getting through to her. As to Michael Gabriel, his statement was part of discovery. Our investigator independently located him. Her position had been that this witness was going to verify the medication was given. I told her repeatedly in our conference room that he was not going to be any help. Repeatedly, he's not going to be any help. We talked to him, the prosecutor talked to him. Doesn't want to be involved, and he's not going to be any help. She took that to mean she should go to his house. And again, Your Honor, I did provide her with the statement because it was part of discovery. That was one aspect of her defense initially. As the court's aware, I didn't do anything to have her locked up. There was a motion filed by the state, which the court granted. I'd like the record to reflect that we discussed reinstating her bond at the last hearing last week. The request was denied. I don't believe there are Brady violations at this point. I don't believe there is a motion to grounds for a motion to dismiss, or I would have filed that. I've explained that to Ms. Jurnasak, but she's been reluctant to accept that.
So I gave him evidence with the letter that I wrote you a week ago with the blood pressure medication that they said was not in the urine sample, or they said all of the woman's medications were in there except for the Dilaudid, which is not correct. The Dilaudid is not in there. The metoprolol blood pressure pill that woman takes twice a day, every single day, including the morning of the urine screen, is undetected, as well as the vitamin D and calcium.
All right, we're not going to have an argument about what the evidence is going to show or not show at trial. Okay, you were appointed representation by the Public Defender's Office. The Public Defender assigned Mr. Fatika to represent you in that case. He did ask at our hearing last week while we were in chambers to reinstate the bond. I said I was not going to do that. So we're going to proceed, and you're going to have Mr. Fatika. Now, it's not unusual for clients of the public defender to ask that they get a different public defender, okay? But we're not going to do that. You were assigned the public defender. Public Defender's Office assigned Mr. Fatika. Mr. Fatika will represent you going forward. Call your first witness, Ms. Blake.
Thank you, Your Honor. The state of Ohio would call Jessica Muscle.
Would you step forward, please? And raise your right hand. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, have a seat right here. And you can adjust that microphone, but I need you to make sure you speak into it, okay?
Will do.
All right. Ms. Blake?
Thank you, Your Honor. Good afternoon, Ms. Muscle. Can you hear me okay?
I can, thank you.
Could you identify yourself and state both your first and last name and spell your last name for the record?
Jessica Muscle. My last name is spelled Mussell.
And can I ask you, where do you work?
Vista Springs, Quail Highland Assisted Living Facility.
What is your role there?
I am the Health and Wellness Director.
How long have you been employed there?
Over 4 years.
As you said the Health and Wellness Director, is that your title?
It is.
Do you use a secondary title
Yes.
there? And can you explain what that is?
The Assistant Director of Nursing.
What are your job responsibilities?
I oversee staffing, monitor the charge nurses, daily duties.
Do you have any patient care responsibilities?
At times I do.
Were you employed there in September of 2023 then?
I was.
Do you know Elizabeth Jernasek?
I do.
And can you tell us how you know her?
I hired her as a nurse, a charge nurse.
Do you remember approximately when that was?
I don't.
Was she employed at Vista Springs in September of 2023?
She was.
Do you know a woman by the name of Margaret Myers?
I do.
And how do you know Margaret?
She is a resident in our community.
She's still currently a resident.
She is.
Was Margaret Myers a resident at Vista Springs Nursing Home in September of 2023?
She was.
Did there come a time in which Ms. Jernasek and Ms. Myers would have known each other?
Yes.
And can you just explain how that was, or how that would have come about?
Elizabeth was assigned to the unit that Margaret Myers resided on as her charge nurse.
Do you remember what that unit was?
We call it Assisted Living 1.
And what exactly, can you just describe that unit briefly for us?
Yes, it's a 35-bed unit, first floor of the assisted living facility.
Did there come a time in September of 2023 when you became concerned about Ms. Jernasek's administration of Dilaudid, also known as hydromorphone, to resident Myers?
Yes.
And can you tell us the circumstances that led to your concern?
The charge nurse that was working that unit that day, also assigned to Ms. Myers, brought it to my attention that she had,
Objection. Overruled.
there had been a new order for hydromorphone to be administered to her.
Okay. And was there any background related to Ms. Jernasek and her administration of Dilaudid that piqued your concern as it relates to Ms. Myers?
Yes, she had received disciplinary action in the past.
At Vista Springs?
Yes.
And can you describe for us what that was?
We had disciplined her for signing off administration of Dilaudid on a day that she was not scheduled and working at Vista Springs.
Was there any other incident?
Yes, there was medication error with another resident there as well.
Would that be Carolyn Patton?
Yes.
Could you summarize briefly just what exactly Ms. Jernasek indicated on the records that she was doing versus what she should have been doing?
For which one?
Ms. Patton.
For Ms. Patton, it was a medication error. She had signed off that she had given 2 doses when the dosage was 1.
So essentially a double dose of Dilaudid was signed out for Ms. Patton?
Correct.
And that happened on 2 different occasions?
It did.
If I told you that was August 23rd and September 6th, would you have any issues, of 2023, would you take any issues with those dates?
No.
Now, did anything happen on September 11th, 2023 that raised your concern about the defendant's administration of Dilaudid and Ms. Myers?
Yes.
And what was that?
That order of that strength and that frequency was unusual for Ms. Myers. In my experience, I had just transferred her days prior and did note that she would be in the condition that she would need that high level of medication and that frequency as well.
So I want to back up for 1 second. So was Ms. Jernasek signing what you know to be drug documents, a controlled substance abuse record, and a medication administration report indicating that she was administering Dilaudid to Ms. Myers?
Yes.
And do you remember how many times she signed those documents on September 11th, 2023?
I recall 3 times.
If you could tell us then, so for record-keeping purposes, does that mean essentially that the nurse, in this case Ms. Jernasek, is alleging at those 3 times she's administering Dilaudid to Ms. Myers?
Yes.
You indicated there was some concern about whether Ms. Myers actually needed Dilaudid.
Yes.
Was she reporting any pain, to your knowledge?
It was documented that she was.
By who?
Ms. Jernasek.
Was it documented by any other nurses that were responsible for her care?
I would have to look at the records to be sure of that. I wouldn't recall.
To your knowledge, were there any other nurses administering Dilaudid to Ms. Myers?
Again, I would have to look at her medical records to know.
Did you have enough concern about Ms. Jernasek's administration or alleged administration of Dilaudid to Ms. Myers that you took additional steps?
Yes.
What did you do?
I obtained a urine specimen order for
How
a
did you go about
toxicity
doing
screen.
that?
I contacted a nurse practitioner,
Who is that?
Sandra Sayakowski.
Do you remember what Ms. or Nurse Sayakowski,
That's correct.
what her relationship was essentially to your facility at the time?
She's the nurse practitioner of many of our residents, including Ms. Myers.
Who employs Nurse Sayatowski?
She works through UH Lake Health Nurse Practitioner Group.
Is it fair to say she's essentially stationed at Vista Springs? Is that a way to say it? Or that Vista Springs is one of the facilities that she's responsible for?
Correct.
So you obtained, I want to make sure I understand this, so you went to Nurse Sayatowski, and what did you specifically ask her for?
I asked her for a urine toxicity screen because I had a concern based historically on questionable documentation and errors.
Regarding Dilaudid and the defendant?
Correct.
Did Nurse Sayatowski write that order?
She did.
And to be clear, who was the urine screen for? Whose urine were we going to test?
Miss Myers.
And what was the purpose?
Because it was documented that she had received 3 doses within the last 24 hours. So the purpose was to document that it was either present or not present.
Okay. And when we talk about that, when we talk about your concerns, if you were asked what the primary purpose or your intent was in obtaining that toxicology screen or that urinalysis, what were your concerns when you asked for that test to be ordered?
My concern was that for the client, if she is being medicated appropriately or inappropriately, or there was a potential diversion or medication error.
When you say diversion or medication error, you mean a drug theft or the nurse administering?
Objection. Overruled.
When you say, well, you can tell us, what do you mean when you say drug diversion?
Taking medications
So a
that
drug
are unauthorized. Theft, correct.
Versus a situation where there might have been a mistake made by a nurse.
Correct.
So you wanted to see if there was a mistake versus a theft offense.
Yes.
Now, was that toxicology screen done for purposes of a criminal prosecution?
No.
Are you required by law to conduct your own sort of administrative inquiry if you believe there might be a drug diversion going on with a nurse at your facility?
Yes.
With respect to patient care, I want to talk about patient care for a second. Why was it important for you to determine whether Miss Myers was being given that Dilaudid?
With respect to her care, she's an elderly woman. Dilaudid is a very high-dose narcotic pain medication. And I had just recently toileted her, transferred her, and didn't note her to be in any pain. So if we're giving an elderly woman a very high dose of routine medication multiple times a day, then it can cause sedation, it can cause overdose, it can cause just a general decline because she's too sedated to eat, drink, and do her normal routine.
Was she exhibiting any side effects that are known with Dilaudid?
No.
Was there any additional action that Nurse Jernasik took regarding asking for, well, let me strike that. Let's back up for a minute. The Dilaudid prescription that Miss Myers had at that time, was it a scheduled dose or was it a PRN, meaning as needed dosage?
I believe it was scheduled.
Okay. Now, is the nursing home responsible for the care of Miss Myers? Is that a fair statement?
Yes.
I want to talk to you a minute now about the administrative decisions you said also played a role in your decision to ask for a toxicology screen. Did law enforcement direct you to ask for a toxicology screen?
No.
Did you consult with law enforcement prior to doing this?
No.
Are you required to investigate internally or administratively any concern you may have about a drug theft?
Yes.
Did you get the toxicology screen with further or future criminal prosecution in mind?
No.
Did you know where Margaret Myers' urine was sent to be tested?
Yes.
Where was that?
I was initially transported to Tri-Point Medical Lab.
Do you know whether they sent it off from there?
Yes, when I called to follow up and check on it, they told me that they had to mail it out, that they did not do a toxicology screen in-house.
Did you talk to the lab that ultimately tested the urine?
I did.
Did you ask them to do this for law enforcement or criminal prosecution purposes?
No.
Do you remember the day that you got the toxicology screen back?
I don't.
But do you remember getting it back?
I do.
And what decisions did you decide to make based on the toxicology screen?
First off, of course, I notified my immediate supervisor. I notified Sandra that I received, Sayakowski, the nurse practitioner, that I had received the results. And then we ultimately ended her employment.
Ms. Jernasik's employment? At the time you ended Ms. Jernasik's employment, if I told you that date was September 20th, 2023, would you have any issue with that?
No.
At the time you ended her employment, did she make any comments to you at that point?
During the time, she said, I did, when I had said, you know, we know that you didn't give this medication. And she said, I did. And I said, well, it wasn't in her urine. You know, we tested her urine. And she wasn't really argumentative about it. She just said, okay, and we said, you know, we have to report this to the Ohio Board of Nursing. That's our duty. It's a requirement. And she questioned if she could come back and work for us afterwards. And, you know, I said to her, you have to deal with the Ohio Board of Nursing, that I had known nurses in the past that had made mistakes and were given either narcotics restrictions in the future or that they were able to practice again, but that would, you know, be something that she would have to deal with the Board of Nursing.
And did she make any other comments?
Not that I recall.
Okay. Did you call the Lake County Sheriff's Department, or did your facility call the Lake County Sheriff's Department on September 20th, 2023?
I believe Amy did.
And who is Amy?
Amy Ablisi Coco. She's the managing partner for Vista Springs, or she would also be known as the executive director.
Is that because your nursing home's required or mandated to report this?
Yes.
What would happen to you if you didn't report?
My license could be in jeopardy.
When the Sheriff's Department came out to Vista Springs that day, were you asked whether the nursing home wanted to criminally prosecute?
We were.
And what was the response?
No.
Has anything about that actually changed?
No.
Okay. If someone were to ask you, was your primary purpose in obtaining that tox screen to aid in criminal prosecution of Elizabeth Jernasik, what would you say?
No.
And had that even entered your mind at the time you asked for the tox screen?
No.
Thank you, Ms. Muscle. Give me 1 second. No further questions, Your Honor.
Mr. Fatiga?
Thank you, Your Honor. Ms. Muscle, had you met Ms. Jernasik prior to her employment at Vista Springs?
I believe that we may have worked at the same facility many years ago, but I don't have a clear recollection of meeting or working with her prior.
Okay. About what time frame would that have been?
I was employed at Golden Living from 2004 to 2014.
Okay. Now, if I understand this correctly, you're saying your primary purpose was for patient care, right?
Yes.
But you've known all along that you're a mandatory reporter, right?
Yes.
And you know if this tox screen comes back negative, that law enforcement will be involved, right?
I would assume that they would get involved.
No, let's not assume. You're a
Okay.
mandatory reporter.
Yes.
They have to get involved.
Yes.
It's not an assumption, right? There's no way around it.
I have to report what I know, yes. That's the question you're asking.
And Ms. Jernasik was arrested at Vista Springs, wasn't she?
Not to my knowledge, no.
Not to your knowledge? Where was she arrested? On what day?
I have no clue where she was arrested or when.
So on the 20th, she was, her employment was terminated, she walked out the door.
She did.
Okay. And again, when the first that you heard about law enforcement being involved was when Amy called the sheriff on the 20th.
Yes.
Now, you made a reference to historical issues.
Yes.
Okay, what does that mean?
There was questionable decisions made of her administration, dosing, documentation.
At your facility, at Vista Springs?
Yes.
And you were conducting an internal investigation based on those questionable, what you're saying are questionable decisions.
Yes.
When would you say that started?
Probably after the first error that we noted.
And when would that have been?
I would have to have the documentation in front of me to know for sure, but it would have been involving the Cecil Lucci issue, which I think was in April. It was Easter, I believe. And then as well as the Carolyn Patton time. So it was during that time.
Okay, and you were aware that she had a prior interaction with the nursing board?
I am.
And did that have an effect on your decision to start an investigation?
No.
One moment, Your Honor.
It doesn't help me when you talk, when she's talking, because I can't hear her, okay? For the purpose of this hearing, we want to get out that, you know, they're saying it was an administrative inquiry, but again, everybody knows that this was going to lead to law enforcement. Well, where did you get arrested? Where? At your house, okay. On what day? Okay. Well, that's the day they're saying that's when you got fired. Okay. Hold on. Where's it, where did that happen? When? When was that? When?
Was there ever a point in time when the sheriff was involved with Ms. Jernasik at Vista Springs,
Not that I recall.
specifically in May of 2023?
Not that I recall.
If the sheriffs would have been involved, is that something you would have known about?
Potentially.
Well, is there a way that you wouldn't have been aware of it?
I'm not there 24/7, and I personally called the sheriff's department for issues with other employees in the past or things going on in the parking lot. So if they were involved with her, I might not be aware.
Okay, but you didn't make any calls pertaining to Ms. Jernasik?
No.
Nothing further, thank you.
Any redirect?
Yes, Sharon, thank you. Just a couple things, Ms. Bussell. First of all, I want to clarify. Defense counsel has asked you some questions about whether you had any knowledge of the sheriff's department having had any prior dealings with Ms. Jernasik at your facility. Do you?
No.
And did anything like that play any role in your decision to ask for a toxicology screen from Margaret Myers?
No.
Now, we talked about, defense counsel asked you some questions about historical issues playing a role in your determination to ask for a toxicology screen of Margaret Myers. Let's go through for a minute those historical issues. You indicated the issues with Resident Patton and Resident Lucci, right?
Yes.
Was it dilaudid every time?
Yes.
Was it on the same unit, the assisted living units of Vista Springs Nursing Home?
One was on one floor, one was on the other floor.
Is there any functional difference in them being assisted living unit 1 versus living unit 2?
No, there's separate nurses assigned to each unit. So she would have been assigned to one unit one day and the other unit another day.
Are the units themselves, because they're called assisted living units, run the same way?
Yes.
Are they the units that Ms. Jernasik would have had access to in her role as a nurse?
Yes.
Did the patients themselves share any common similarities that you could recall, such as age or condition or things of that nature?
Hospice, 2 of them were hospice patients.
What does that specifically denote in your facility?
So they're on a decline, they're declining, their age, their health, they'll have comorbidities, and their pain is managed typically with morphine or Dilaudid, depending upon their diagnoses, which is prescribed, or allergies, things like that.
Do they have memory issues sometimes?
Sometimes, yes.
And would there have been difficulty in them recalling whether they were given their medications?
Objection. I'll sustain that.
So with respect to the historical issues, is there any other similarities regarding the other 2 incidents that, with Ms. Patton and Mr. Lucci, that are similar to this incident with Ms. Myers?
As I recall, both residents and Ms. Myers all received their medication crushed in applesauce for administration, so they might not know exactly what was being administered.
Now, there were some additional questions about your internal investigation that might have started as soon as the medication, I'll say, discrepancies with resident Lucci. Did you ever consult law enforcement about that?
No.
And when I say law enforcement, I mean the Sheriff's Department, I mean the Ohio Attorney General's office.
No.
Did you ever ask for law enforcement's direction or guidance in how to proceed?
No.
In your role as the Assistant Director of Nursing in the Health and Wellness Officer or Director, is the administration of the nursing home, how it's run, part of your daily responsibilities?
Yes.
There came a point in time in which you did speak to the Ohio Attorney General's office. Maybe you remember Agent Joe Schoenbarger.
I do.
Do you remember when that was in relation to the termination of Mr. Nasik?
No.
Was it before or after?
It was after, yes.
Prior to that time, had any law enforcement agency even talked to you other than the Sheriff's Department?
No.
And had any law enforcement agency, including the Sheriff's Department, asked for the toxicology screen?
No.
Now, when the Ohio Attorney General's office became involved, did you turn over the records that you had related to this case?
I did.
Was the toxicology screen part of that?
I believe it was.
Was your purpose in asking for the toxicology screen to give it to the Ohio Attorney General's office at some future
No.
date? Did you or your nursing home ever call the Ohio Attorney General's office?
No.
Do you know how the Ohio Attorney General's office became involved?
I believe the Board of Nursing.
And so the Board of Nursing, they're an administrative agency, is that correct?
Yes, there are licensing.
So the Board of Nursing, to your knowledge, the Board of Nursing made a referral to the Ohio Attorney General's office.
Objection. Overruled.
To your knowledge?
Yes.
If you give me 1 second, Ms. Mussel. No further questions, Your Honor. Thank you.
Cross.
Okay. The way I understood it, going back to September 20th, 2023, you got the Ms. Myers toxicology report. Somehow, Amy, I can't pronounce her last name.
Coca.
Okay, you advised her what happened.
Yes.
Okay. And a decision was made to contact law enforcement, right?
She was terminated first.
Right,
She was terminated first.
right. And now answer my question. At some point, because you're mandatory reporters, right?
Yes.
It's not a matter of discretion. You have to tell law enforcement.
I'm not sure which happened first. I believe she contacted the Board of Nursing and took directives from them, but that would be a better question for her.
Are you
because-
talking about Amy?
Yes,
Okay.
because I did not contact.
Okay, but you let
Either
her
party.
know.
Yes.
Okay. And then at some point you were contacted by the AG's office.
Yes.
Now, you heard, or you had questions on redirect about 2 other patients, Ms. Patton and Ms. Lucci. You recall that?
Yes.
Okay. And isn't it true that all the patients there share some similar issues on these assisted living floors?
Age-wise,
Okay,
yes, they're all elderly.
okay. And you said they're all in hospice?
No, they're not all on hospice.
Okay, just these two?
Those two are,
Okay.
yes.
How many are in hospice of the 2 floors? Or
Out of the
what
whole,
percentage?
I mean, if there's 70 people between the 2 floors, maybe 15.
50 or 15?
15.
Okay.
That's probably a high number, but
Okay, but it wasn't these three, in other words, Ms. Meyer, Ms. Patton, and Ms. Lucci weren't the only three?
no.
And you talked about medication crushed in applesauce. That wasn't unusual to this situation, right?
It's not unusual.
I mean, that did raise any red flags with you?
No.
Now, you've been a nurse for how long?
20 years.
Okay. And you heard on redirect, there's a question about, the nursing board and the assistant attorney general. They're administrative agencies, right?
Yes.
But in your experience, they can take criminal action as well. Wouldn't you agree?
Yes.
Nothing further. Thank you. Your Honor.
You can step down, thank you. Next witness?
Yeah, if you could stick out. If you could hold out.
Your Honor, the state would call Deputy Dustin Majewski from the Lake County Sheriff's Department.
You raise your right hand, please. You swear testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God. All right, let's- And stay close to that mic, okay?
Yes, sir.
Thank you, Your Honor. Good afternoon, Deputy. Could you identify yourself for the record, stating both your first and last name, and spell your last name for us?
My name is Deputy Dustin Majewski. Last name is Majewski.
I've been saying your last name wrong. Majewski is the correct saying, is that right?
Yes,
Okay. Where are you employed?
with the Lake County Sheriff's Office.
And how long have you been employed there?
Approximately 9 years.
You were employed by the Sheriff's Department in September of 2023.
Yes, ma'am.
Could you describe for us, particularly in September of 2023, what your duties with the Sheriff's Department would have been?
That day I was assigned to road patrol in the Concord Township area.
As part of road patrol, what are your daily responsibilities?
Ranges anything from investigations, crashes, traffic, criminal matters.
Are you sometimes called out to investigate incidents just simply to take reports rather than actually pursue a criminal prosecution?
Yes.
Now, I want to direct your attention to a report you took on September 20th of 2023 at Vista Springs Quail Highlands Nursing Home. Are you familiar with that, first of all, that call you got in the report that you produced as a result?
Yes, ma'am.
Now, can you tell me why you were dispatched to Vista Springs?
It was initially a report of a possible drug theft that was occurring at the location.
And do you remember who called you?
I believe it was Miss Muscles. I don't know if I pronounced that right, but it was one of the healthcare workers.
There's a director.
Objection?
Overruled.
Would you know the name Amy Basila Coca?
Yes.
And would it have been one of them essentially that might have called you?
Yes, I did end up speaking with her.
Okay. When you arrived at Vista Springs, who do you remember talking to?
It was both Miss Muscles, Miss Betsy Coca, I mispronounced her name.
I do too, it's okay.
And I believe there was another healthcare worker there by the name of Mr. Woolnow.
Okay. What did you learn in speaking to them?
From speaking with them, they had suspicions that another employee was supposedly giving one of their residents, I believe the name was Miss Myers, narcotics on paper, but there was no, or the nursing staff had said or brought to their attention that they did not believe that Miss Myers required that medication.
Now, do you know who the nurse was that they were saying they had concerns about?
It was Mrs., and again, I'm going to mispronounce this, Jernasik?
Okay. Was she still employed there at the time that you arrived?
No, she was not.
Was she still in the facility?
No,
Did you arrest her?
no,
Did the sheriff's department ever physically take her into custody there?
no, ma'am.
Now, when you were talking to the management staff there and the nurses at Vista Springs, did a toxicology screen come up at any point during that discussion?
Yes, there did.
And what, if anything, did you learn about the toxicology screen?
It was requested by the facility themselves, and in the tox screen, it showed that there was no evidence of the drug or its breakdowns in Miss Myers.
Did you advise the nursing home to order that toxicology screen?
No, I did not.
By the time you became involved in the case, had Ms. Jernasik already been terminated?
Yes, ma'am.
Did you collect the toxicology screen?
No, I did not.
Did you speak to Miss, I think it's Basiley Kopka maybe, and Miss Muscle about whether the nursing home wanted to criminally prosecute Ms. Jernasik?
Yes, I did.
Did you take statements from any of them?
Yes, I did.
What did they indicate with respect to whether they intended to criminally prosecute Ms. Jernasik?
At the time, they denied wanting to pursue charges on behalf of the facility.
Did it appear to you in any way that they had collected the toxicology screen or ordered the toxicology screen?
Objection. Go ahead, finish the question.
Did it appear to you, based on your investigation, that they had ordered the toxicology screen in furtherance of criminal prosecution?
Objection's overruled.
Did it appear to you that the nursing home management staff had ordered the toxicology screen of Ms. Myers in furtherance of criminal prosecution, or in hopes of criminally prosecuting Ms. Jernasik?
No, ma'am.
Did criminal prosecution, again, based on your investigation, play in at all to their determination to get a toxicology screen?
No, it did not.
Did you ever advise them, or to your knowledge, did any law enforcement agency ever advise them to seek a toxicology screen of Margaret Myers?
No, ma'am.
I don't have anything further, Deputy. Thank you.
Cross-examination?
Thank you, Your Honor. Okay, you indicated that on September 20th, 2023, you're on road patrol. And you indicated that one of your duties is to take reports, right?
Correct, sir.
Okay. And those reports usually lead to criminal prosecutions, right?
Sometimes they do, yes.
Okay. Well, most of the time, wouldn't you say?
Objection.
Overruled.
I would say it just depends on the case, sir. It doesn't mean that there is going to be criminal charges or there isn't.
Okay. And in this situation, you took the report, and what did you do with it?
It was requested that a formal report be filed on behalf of the facility as part of their reporting requirements.
Okay. And where did you file it?
It was filed with our office.
Okay. So, if I understand you correctly, well, who contacted you from Vista Springs?
It was, like I said, it was Miss Muscle and Miss, again, mispronounced,
We'll say Miss
Leslie Coca. Yes.
Okay. And you have a specific recollection of talking with Ms. Muscle on September 20th?
I do remember speaking with her, yes.
And if I understood you, they weren't, you're saying on direct, they weren't requesting criminal prosecution, but they were requesting that you file a report.
They were requesting to file a report, yes.
And they're mandatory reporters, right? If you know.
That I'm not positive on because I don't know what the requirements for the nursing home are.
Did you speak with anyone there? You mentioned Coca Muscle, and who was the male?
I believe it was Woolnow.
And what was his role in this?
He was one of the staff that was in charge of care for Miss Myers.
And at this point, on September 20th, 2020, you had never met Ms. Jurnisek.
No, sir.
And if I understood you, the impression I got was this ended your participation in this case, right?
I'm sorry, what do you mean, sir?
You filed a report, and then were you involved at a later time
No, sir.
in this case?
No.
Okay. Nothing further. Thank you.
Redirect?
If I could have 1 second, Your Honor.
Yeah, he's got relatives all over, I bet.
Deputy Defense Counsel asked you some questions about the end of your involvement in this case being after you took the report. Is that right? That was the end of your involvement?
Yes.
When you are referring a matter for criminal prosecution, what do you do with your report?
If criminal charges are warranted or requested by the victim, then we will either do a number of things. It could be forward the charges to the prosecutor for review. It could be forwarding it to the court on those charges and either requesting a summons, or we may even ask for a warrant on the case, or we may just arrest the person.
Did you do any of those things in this case?
No, ma'am.
Did you go out and seek Mr. Nasik for arrest?
No.
And at the time, you had knowledge of what the toxicology screen indicated, is that right?
Yes.
Defense counsel asked you some questions about the nursing home's reporting requirements. Was it your understanding from talking to the nursing home that when they were calling you, it was to fulfill their administrative reporting requirements?
Yes, I believe so.
So they were asking you to file a report to fulfill whatever administrative regulations they had.
That was my understanding.
Nothing further, Your Honor. Thank you, Deputy.
Recross.
All right. Let's revisit. You're saying administrative requirements? That Vista Springs had an administrative requirement to report?
As I understand, because of the nature of the facility, there were certain agencies that they had to make a report to.
Okay. And that's mandatory, right? That's mandated by law?
That I don't know, sir.
Okay. Is it your understanding that this is an internal administrative policy of Vista Springs, or are there forces outside of Vista Springs that require them to report?
As I understood, there were drug enforcement agencies and nursing agencies also involved that they would have to report to.
Thank you. Nothing further, Your Honor.
All right, you can step down, thank you. Any other witnesses?
No, Your Honor, thank you.
Mr. Fatigue, any witnesses for the defense?
No, thank you, Your Honor.
Do you want to argue this issue before we get to the next issue?
Yes, Your Honor, thank you. Thank you. Your Honor, well, first of all, this relates to our motion to determine admissibility of evidence, obviously, and the primary issue here, Judge, is whether the state has to call the scientists that essentially conducted the testing, in this case on the toxicology screen. There's two records at issue. It's UH's business record of the toxicology screen and its results. For purposes of clarity, I'll just refer to it as UH. The court knows there's been a change, I guess, in who owns that hospital. But for purposes of clarity, there's UH's business record as it relates to Margaret Myers' tox screen. The reason they have that record is because it was their nurse who ordered the tox screen to be done. When Margaret Myers' urine gets to, at that point, the facility was Tri Point, there's a Tox Assure 25 test that is ordered. That's the test. That test is sent out to MedTox. MedTox is a subsidiary of LabCorp, MedTox runs the testing that they would in the usual course of business, in the usual way. They produce the result and the data analysis. MedTox and or LabCorp keeps that record as they would in the usual course as a business record. They also, because UH was the referring hospital system, I guess if we think of it that way, they send a copy of that record back to UH. So what we have is we have UH's certification of that record, the tox screen and the results as a business record, and we have MedTox/LabCorp. I've used the terms interchangeably, but MedTox and LabCorp's business record of the tox screen itself and the result. On their face, Judge, we think they're business records. We think they clearly meet the criteria under 8036 and 902. They're made and kept in the usual course of business in the usual way at or near the time of the event being the tox screen in this case. And they're true and accurate copies of that. We have the indication that they are. The reason we're further discussing this today, Your Honor, is for further clarification, and what we're asking for is an order determining the admissibility of those business records, but also testimony from the non-testifying testimony from the non-testing scientist.
Labard.
Yes, Mitch Labard. We also have an expert opinion, or opinions really, that have been produced based on the truth of the record, the truth of the tox screen. It's the state's contention, Your Honor, that we do not have to produce testimony from the scientist at LabCorp, or the scientists, there may be many, quite frankly, that actually ran the test at LabCorp and or MedTox's facility. And the reason for that, Judge, here is, well, it's twofold. A couple things that are important. The inquiry really is whether, and Mate sees it, would violate the confrontation clause. There's two things that the court has to address. Are the records being admitted for their truth? Clearly they are. We wouldn't be here if the state was saying we don't believe the record. The records are clearly offered for their truth, Judge. The second inquiry is whether the records and the testimony, the out-of-court statements about those records that led to the record being produced are testimonial. It is not testimonial. The case law on this is clear. We look at Smith versus Arizona, very recent case in June of 2024, Judge, and Smith versus Arizona lays out the framework for us deciding what testimonial evidence is. The inquiry is simple. The inquiry is what was the primary purpose? What was the primary purpose? So if we look to this case and we look at the tox screen and we look to what the primary purpose was, it's on. And Smith versus Arizona, Judge, talks about when the primary purpose is for criminal prosecution, that's when we have a document or evidence that becomes testimonial in nature. When the primary purpose is something other than criminal prosecution, it is non-testimonial evidence. And what we have here is quite clearly non-testimonial in nature. You look at these cases that have been decided prior to Smith, like Bull Cumming and Melendez-Diaz. In Bull Cumming, Judge, we have a defendant who is arrested as the driver of a car. His blood is seized, and his blood is seized so that there can be a determination as to whether he's driving impaired. So the blood is seized and analyzed. In Bull Cumming, the state in that case, I think it was New Mexico, tried to admit the report and testimony from the non-testing scientist as to the veracity of the report, essentially. In that case, it's very clear that those things were first offered for their truth, but secondarily, very clear the primary purpose of the blood test. The primary purpose was criminal prosecution. The man was arrested driving the car, and the blood was seized for the purpose of determining whether he was impaired. In Melendez, there was no other purpose. In Melendez-Diaz, a defendant is, I think, walking down the street, is arrested, has cocaine or some sort of substance in his pocket. That substance is seized. Defendant is arrested. The substance is sent to a crime laboratory that is run by the state of Massachusetts, and it reveals that it's cocaine. The testing was done for one reason. The testing was done to determine whether this person should be charged with possession of cocaine. In both of those cases, it was at the behest of law enforcement. This case is very different. And I would point out that it's such an important determination as to whether the evidence was testimonial that in Smith versus Arizona, Judge, the United States Supreme Court would not address that issue because the lower court did not. The United States Supreme Court said, look, it's clearly being offered. There's a similar test result being offered for its truth, but we're sending it back to the lower court because the lower court did not address whether it was testimonial, meaning whether it was obtained for the primary purpose of criminal prosecution. Here in this case, Judge, you've heard testimony. You've heard testimony from Jessica Mussel, the Assistant Director of Nursing at Vista Springs. You heard testimony from Deputy Majewski. It's very clear that this case is different than Bull Cumming and Melendez-Diaz. In this case, Judge, first of all, it's not the defendant's urine that was seized. I would point out that it is somewhat, I think, noteworthy that it is the resident's urine that was seized. And secondly, the primary purpose of the tox screen was patient care. And for them to make an administrative decision on what they needed to do regarding Nurse Jurnasik's employment and to follow whatever administrative duties they may have had. Interestingly, Ms. Mussel today testified, Judge, that the tox screen could have been run to exonerate Ms. Mussel as well, or excuse me, Ms. Jurnasik as well. So there's no evidence that that toxicology screen was in any way produced for law enforcement purposes or criminal prosecution. Again, the fact that it's later used in criminal prosecution is not the inquiry. If that were the inquiry, we wouldn't have the test about primary purpose. The fact that a test or a result or out-of-court statements from a non-testifying scientist are being later used in a criminal prosecution is not what is determinative. It is not important. Whether this toxicology screen is the state's key piece of evidence or some ancillary piece of evidence, that does not matter either. All that matters is what was the primary purpose at the time the toxicology screen was done. Law enforcement was not even involved. Now, Mr. Fitica will advance, and he has sort of throughout his questions here today, that the Vista Springs knew they were a mandatory reporter. Well, Ms. Mussel said they were a mandatory reporter to the Board of Nursing. They had administrative regulations to do that. There's clearly no determination and no thought on their part toxicology screen would be used for criminal prosecution. They thought it was over when they declined to prosecute criminally. That was not the primary purpose of this tox screen, and there's no evidence to suggest to the contrary. Even if at some point the toxicology screen becomes relevant for a criminal purpose, doesn't matter. That is not the relevant inquiry here. And the United States Supreme Court could not have been clearer. If we just simply said, well, this tox screen is important in this case and it's being used for a criminal prosecution, we would never have this discussion at all in any case about what a primary purpose is. The Supreme Court, I suspect, would not have spent decades trying to define for us what testimonial means and what primary purpose means if it meant, hey, you're going to use that in a criminal prosecution, that must be your primary purpose. In this case, there's clear evidence as to what the primary purpose was, and criminal prosecution never entered Jessica Mussel's mind. She didn't want to be here today, and the court could see that. She still, Vista Springs Nursing Home still does not want to be participating in a criminal prosecution. So I think at this point, Judge, the record is clear. There's no violation of a confrontation clause in this case. The state is seeking a ruling from this court allowing the admission of both UH's certified business record of the toxicology screen and its results. The state is seeking a ruling as to the admission of MedTox / LabCorps, again, business records of the toxicology screen and the results. The state is further seeking a ruling from the court that it does not need to be the testing scientist or certifying scientist that testifies regarding that toxicology screen and the result. And third, the state is seeking a ruling that if otherwise properly tendered, any expert opinions that are based on the truth of that tox screen can be offered. That is why we've asked for this hearing. That is why we've supplemented our motion to determine admissibility of evidence. And I would also point out, if the defense finds that these people are so very important, the defense is free to call them as well. The issue is just whether the state has to. And in this case, the law is clear that the state does not. So we would ask the court to issue those rulings as we've outlined in our motion.
So authentication of MedTox and UH self-authentication, right? Business record exception on both. Labard instead of the testing.
That we don't need the testing scientist.
And reference by other experts that you're having with regard to the results of the MedTox.
If otherwise
Test.
properly tendered, yes. Labard could, he sort of in this case serves a dual role. He could also be one of those experts.
All right, okay, Mr. Fatika.
Thank you, Your Honor. I think it's somewhat disingenuous to say that this was never on the radar for a criminal prosecution. Because on the one hand, we're hearing about there was an investigation at Vista Springs. I believe it started in May of 2023 was a reference. So, and then nobody contemplated that law enforcement would ever be involved. That's what they want the court to believe.
But is that really relevant?
It is from this perspective. That the screen comes back positive and they call law enforcement that day.
Negative.
They make a report that day.
Comes back negative.
Or when it comes back
Right,
negative.
right.
I apologize. The state says, well, we could call the testing scientist, but we don't have the burden of proof here. We do have a right to confront. I think the jury needs to know what procedures were followed or not followed in collecting this sample from Ms. Meyer. But again, I just think it's disingenuous to say, well, we want to put this case in context or in perspective based on this lengthy investigation from Vista Springs. You heard Muscle referred to historically, I think was the word she used. And then we're all going to kind of turn a blind eye to the fact that this was going to be a criminal prosecution.
Well, wouldn't that, to Ms. Blake's point, wouldn't that make all the testimonies by someone such as Labard, wouldn't that make it all testimonial? I mean, if the test is that does law enforcement eventually get involved, even though they weren't at the start, wouldn't it all be testimonial then? What would be the distinction?
But I think the distinction is law enforcement, they might not have been quote unquote involved, but they're mandatory reporters. There was no way they were not going to be involved if this came back negative, and everybody knew it. And what buttresses that argument is the fact that the day it came back, the day that Ms. Meyer's test came back negative, deputies there taking a report.
What about when it's if that were true, that everybody knew it was going to be a criminal proceeding, then you have a kind of a dual role of this test, right? They have to do it, okay? Administratively, they have to find out if something's going on within their ranks, all right? So there would be no distinction, though? It's going to be all testimonial, even at best case scenario for you, if it's a dual role?
I think it's important that we have the right to question the person that performed the test.
Under the Sixth Amendment, right?
Right.
Okay, if it's confrontational, right? That's
right.
Okay. Is there, in your theory, there'd be no distinction, though, right?
Well, there would.
It's going to violate the Confrontation Clause regardless?
If this was, I guess the example would be somebody stealing. And, sometimes banks don't want to reveal that they got taken, and it goes no further. The bank knows when they're doing the investigation, whoever was stealing the money, they're not going to pursue. Here, that wasn't the case, because everybody involved, or at least the witnesses, the professional witnesses from Vista Springs, they know they've got a report. And they knew that at the outset.
Okay.
And it's an investigation.
So is there an issue with the self-authentication of the UH and MedTox records?
No, it's the
non. Okay,
sorry.
I just want to make sure what pages we're on here. Is there an issue that they are business record exceptions?
No, Your Honor.
Okay, so the only issue is whether the person that did the test at MedTox has to testify and Labard should be prevented from testifying.
I'm not suggesting Labard should be prevented, but we should have.
Well, under your theory, what would be the relevance of Labard then?
I don't know, if the state thought that he had something to add.
Okay.
But
As to the results of the test, you don't think Labarge should be able to testify as to the results as a fact?
solely, no, I think we should be able to question the person that
The
took the.
person that did it, okay. All right. Okay, so we have some of the stuff resolved by agreement. They're self-authenticating their business, they come in by a business record exception. The only issue would be Labarge and his testimony in lieu of the scientist who performed the test, correct?
It seems.
Okay. Well, isn't it? Or-
Yes, it seems, yes.
Okay. And then, as far as you, Ms. Blake, you alluded to the ability of other expert witnesses to rely on the MedTox test result, as would be in your case testified to Labarge. Are there other?
So there are two expert opinions that the state has sought. Certainly, Mr. Labarge would be one of the other experts, yes.
Okay. All right. So I'll get your ruling on the Labarge situation. Okay. The other ones are resolved. As to Labarge, you had filed a motion to have him testify remotely.
Yes.
I granted that motion, and the reason, I don't know if it's in the entry or not, that it is granted, he's located in Minnesota, correct?
Yes, Your Honor.
He would frequently be required to testify as to, in situations like this?
Yes.
All right, and that's where he's located, that's where MedTox, where he's located with MedTox, correct?
Yes.
Okay, so on that basis, I'll let him testify remotely. We have the issue of the 404B and 29, 45 issues?
Yes.
Do you want to address that?
If I could have 1 second, Your Honor. All right. So, Your Honor, switching gears then to the other acts evidence, the court's aware, and we've talked about it at prior hearings, that the state has filed a motion to intent to use 404B evidence and 294559 evidence, which is essentially a statutory counterpart to evidence rule 404B. There's three pieces of other act evidence, Your Honor, that the state feels is very important to what I would call the natural sequence of events in this case. And before we even get to 404B, before we even get to the rule of evidence, before we get to the statutory issue at hand, Judge, I want to talk about why those three pieces of evidence should come in regardless of 404B. So I want to articulate what those are. You actually heard testimony at this hearing about them, and I think that testimony actually might be helpful to kind of put together the chain of events here. The first piece of evidence, or the first other act, I guess I'll call it, is that the defendant signed out Dilaudid form, or at least indicated on a medication administration report, which is a controlled, which is a drug document by statute. She indicated that she was administering Dilaudid to resident Lucci on April 9th, 2023 at Vista Springs Nursing Home. The defendant was not working that day. The defendant could not have done what she indicated on the records. Now, she was counseled about it. She received some counseling from Ms. Muscle, as you heard, but that obviously, in Ms. Muscle's role as an administrator there at the nursing home, that obviously raises some concern she has. So fast forward to August of 2023, and on August 23rd and September 6th of 2023, Ms. Jernasik, again, has another issue with Dilaudid. She signs those drug reports, again, the drug documents, the controlled substance abuse record, and the medication administration record, indicating that she's administering Dilaudid to Ms. Carolyn Patton, another resident at the
It's August 23?
August 23 and September 6th. And the problem this time, Judge, is that it's a double dose of Dilaudid. So she's signing out more Dilaudid than what the prescription calls for. This is brought to Ms. Muscle's attention by other nurses who are concerned about why this is happening. At that point, Ms. Muscle, again, concerned that this is Dilaudid again, and the same nurse She is, obviously, it's her job to carefully watch what's going on. So on September 11th, and you heard her testify to this, so on September 11th, when Ms. Jernasik signs out Dilaudid again on those drug documents, the medication administration record and the controlled substance record, at 3 different times, indicating that she's administering Dilaudid to Margaret Myers, that raises concern with Ms. Muscle. Ms. Myers had just moved to that unit, and she was not known to need Dilaudid. So at that point, and I forget the term we used, I think it was historical events or historical context, Ms. Muscle knew that this defendant had had some issues, again, on the assisted living units involving Dilaudid. And so she decided, again, administratively, she needed to find out whether there was a drug diversion or a medication error going on here. So a toxicology screen was asked. She asked the nurse practitioner assigned to the unit to order a tox screen. The tox screen was ordered on Ms. Myers, and it came back negative for Dilaudid. At that point, when the nursing home got the results on September 20th, 2023, Ms. Jernasik was pulled off the floor between 9 a.m. and 9:30 by Ms. Muscle. She was terminated by the management at the nursing home. Interestingly enough, the management at the nursing home learned that Ms. Jernasik had already signed the controlled substance abuse record that day, indicating that she administered Dilaudid to resident Patton, originally at 11 a.m. that day, and it had been changed to 10 a.m. That could not have been true. She was pulled off the floor and dismissed from the nursing home prior to that time. That was documented by her, by Ms. Jernasik herself. Those 3 events, Judge, complete the sequence of what happened here. The 2 prior and then the one immediately following her termination. I would ask that the court to consider that you've made similar rulings like this before, and the case that I would point your attention to is State versus William Jackson, which case number 20 CR 558. In William Jackson's case, Judge, the defendant was charged with drug trafficking. In that case, the state sought to seek the introduction of other act evidence that related to drug trafficking. The state did that through a 404B motion. This court ruled that it really wasn't 404B evidence, that in fact the defendant's involvement with drug trafficking leading up to the event charged was part of the sequence of events, was part of the natural sequence of events. That's what we have here with these incidents at Vista Springs. And I would point out, Judge, the defendant, and if the state, if the court has any questions about it, we have the defendant's interview on a flash drive today and are happy to admit it as an exhibit and play it if there's questions about it. But the defendant advanced many theories when talking to the Attorney General's Office and Board of Nursing. And just for clarification, the Attorney General's Office is a law enforcement agency. The Board of Nursing is not. It's an administrative agency. But when she was speaking to them, she advanced many theories of why the nursing home, why Vista Springs did this to her. And one of the theories she's advanced, to use my words, was essentially a witch hunt by the nursing home. She said that she told them about the 4th prior instance of other conduct, which I'll address in a few minutes, but she told them she was fired in 2022 from Tapestry Nursing Home in Wickliffe for taking a bottle of Dilaudid home with her. She asked them to be a reference for her during her proceedings in front of the Board of Nursing. She advanced a theory with Agent Schoenbarger, in this case from the Attorney General's Office, that suggested that the nursing home, Vista Springs, tried to terminate her as a result of that, and that this story involving Margaret Myers was somehow concocted. She also, by the way, further advanced that it was her idea to drug screen Margaret Myers. And I would point that out too, Judge, just to switch gears and go back to the previous motion. If that was the case, we wouldn't have an issue at all about whether that drug screen was testimonial. But she advanced essentially this theory that it was some sort of attempt to set her up. It's important, Judge, for the state of Ohio to be able to introduce those 3 pieces of other evidence or those other acts, because without them, one, it unfairly feeds the defendant's theory that she advanced to the agent from the Attorney General's Office. It feeds this theory of, well, they just, decided that on September 11th, they wanted to fire me because they knew about what happened in 2022 at Tapestry, so they just wanted to fire me. Without the context, Judge, the state doesn't fairly have the opportunity to present the way it actually happened and to refute what the defendant herself has said during her interview with the AG's office and the Board of Nursing. So we think, Judge, that it clearly comes in, it completes the natural sequence of events in this case, even before we get to the threshold questions as it relates to 404B. But under 404B, it would come in regardless. What I would point out under 404B is that all three pieces of those evidence, Judge, or other acts, they all occurred at the same nursing home. You heard Ms. Mussel testify today. They occurred on the assisted living units. They occurred on the units that Ms. Jurnaczek was responsible for, patients under her care. And interestingly enough, they occurred with residents that had a similar order for how their Dilaudid would be administered, essentially. It would be crushed, so the patients or the residents themselves might not know what was actually in the applesauce, if anything at all was in them. So I would point out that those three incidents share in common that Ms. Jurnaczek, and what they share in common with this incident that's charged, Ms. Jurnaczek had the opportunity because of where she worked. I would also point out it shows her intent, Judge, and knowledge. This was not a situation where she didn't know what she was doing. She had been counseled before by the nursing home about her administration of Dilaudid, for a better way to say it, for lack of a better way to say it. And furthermore, it shows the steps, Judge, the preparation that she took. She tried to make those records make sure that it covered her tracks. The records matched the pill count. That's the important part here. The CDR, the controlled drug report, and the MAR, the medication administration record, matched the actual drug count that was left. That's important here. And I would also say, Judge, plan is one of the exceptions. Plan kind of almost goes hand in hand with my argument about it coming in regardless of 404B. Plan is when we talk about how these three events are sort of inextricably linked, and how we can't separate them from the case or from the actual event that's charged. And that's what we have here. If we were to pull back on it and separate them, the event itself regarding Margaret Myers doesn't make sense. It makes it look like the nursing home was somehow out to get Ms. Jurnaczek. And that would be an unfair way for her to advance that possible theory. Finally, Judge, under 404B, those three events should come in as absence of mistake or lack of accident. During her interview with the agents, Ms. Jurnaczek advanced some concern or theory, again, amongst many theories, that possibly her ADHD and or dyslexia played a role in the problem or the issue, I'll call it, as it relates to Margaret Myers and the administration of Dilaudid to her on September 11th. The Ohio Board of Nursing agent confronted Ms. Jurnaczek about this, and when continuously questioned, Ms. Jurnaczek said there must be some other explanation. There's not. It's not a mistake. It's not an accident. We know the whole sequence of events that led up to this, and we believe that should come in, first of all, as the natural sequence of events, the whole story. Even if it doesn't come in that way, Judge, it certainly should come in, we would argue, under 404B. The fourth piece of evidence, Judge, is actually the first one that happened prior in time. It's a 2022 incident, Tapestry Nursing Home in Wickliffe. The defendant, it was January of 2022, the defendant was a nurse, similar situation, taking care of similar patients, similar role at that nursing home. She took a bottle of Dilaudid, liquid Dilaudid. She took a bottle home with her. She took a medication administration record home with her as well. The defendant eventually brought back a bottle of something. It was not tested. That case was not criminally prosecuted. But again, not criminally prosecuted, but because they are mandatory reporters, they referred it to the Ohio Board of Nursing. She went before the Ohio Board of Nursing. Her license was suspended as a result of that conduct. And Ms. Jurnaczek has sort of advanced, as I said, this theory that the 2022 incident is why Vista Springs was trying to get rid of her. What I would point out about the 2022 incident, Judge, is that, again, it's the same opportunity. She's a nurse. She's at a nursing home. She has a medication cart at her disposal. There's Dilaudid available to her. It's Dilaudid every time. It's the same type of care. The opportunity is the same. In addition, the intent, Judge, the intent every time is targeting Dilaudid. The plan, again, avoid detection. Taking it home with her, taking the medication administration record so that that disappears. And importantly, I think when we're talking about the 2022 incident, the defendant, again, interjected the possibility that there was some mistake. She said this could have been related to her ADHD, dyslexia. That rebuts it. This goes right to what the Hartman Court in the Ohio Supreme Court talked about. This goes to her guilty knowledge. So it should come in under 404B. And I would point out, Judge, on that piece of evidence, the 2022 incident at Tapestry, the defendant fully acknowledges it. During her interview with the Attorney General in this case and the Ohio Board of Nursing in this case, she says, I did that. I was wrong. She fully acknowledges it. It's not an unsubstantiated claim. It's a claim she acknowledges and admits. This is not a situation where we have to, have a trial within a trial. She admits she took Dilaudid and the circumstances were the same. So I would offer all of that, Judge, for the reasons I just stated. And the other thing I would say, Judge, is, again, theft is a specific intent crime. I have to prove that Mr. Nasick's specific intent was to permanently deprive Ms. Myers of her Dilaudid. To do that, courts have been very lenient in allowing other act evidence to come in, especially when it goes to intent. We certainly think, number one, the 3 pieces of other act evidence that I outlined are necessary and important to the sequence of events here. And number 2, if nothing else, 404B, they all come in under 404B and 29, 45, 59. So I would ask the court to make that ruling here today. If the court feels that the defendant's comments or interview is important to the court's ruling, the state is happy to admit that as an exhibit just for purposes of today's hearing. We have that on hand, Judge.
The Tapestry incident, if that does not come in under 404B, what is there evidence you intend to support, to present regarding that incident, such as any statements?
So throughout, Judge, and maybe this again might be important then for us to play the defendant's interview. It's about 50-some minutes long. But throughout the defendant's interview, her interview in this case, she repeatedly references the 2022 incident and believes that this firing and this investigation has something to do with the 2022 incident. So it's really important to this case, and essentially, if we couldn't talk about that, the state would be left with basically eviscerating the defendant's interview. This is the defendant's theory. The defendant has advanced to the investigators that because of what happened at Tapestry, because she alerted Vista Springs of it, and because she asked them to be a reference in front of the Board of Nursing, they are somehow trying to set her up here. We know that to be untrue. We can refute that. 404B does that.
Mr. Fatica?
Thank you, Your Honor. I'll start with what I'll describe as the other Vista Springs allegations. And again, going back to our prior discussion, on the one hand, the state wants to say this was not a criminal investigation, this was strictly administrative. On the other hand, they want to use it and they want to give it credibility as involved in this criminal matter. As is obvious, none of these other 3 incidents were presented to grand jury. The philosophy behind 404B.
Well, objection, Your Honor. The defense counsel doesn't know that.
Okay. I'll retract that.
Just go ahead.
Yeah, she certainly wasn't indicted for those counts. So if it was presented, they decided not to pursue it. But the larger concept here is that you can't say she did it these other 3 times, so she did it this 4th time, or these other 4 times. They have to prove their case in this case. I listened to the interview. Ms. Jernasik vehemently denies taking the Dilaudid. In terms of opportunity, in the state's motion, they make reference to the fact that this is a common way that drugs are taken. There's no signature to the way Ms. Jernasek is alleged to have done this in the past. If the court does decide to allow the 3 prior Vista Springs incident into evidence, we would ask for a limiting instruction. Let the jury know that this is only being presented for context. Obviously, she's not being charged with that. She'll be used for that purpose. And again, it introduces a level of confusion because now we have other people, other patients that aren't the alleged victim in this case.
But isn't that the nature of 404B?
Well,
I mean, otherwise you'd have to, I mean, you said a little bit earlier that the grand jury may or may not have gotten this, okay, but they didn't, the state did not pursue charges on these other 3. Therefore, no evidence should come in under 404B, but then there would be no 404B. It would all be counts in the indictment and no other acts, right?
Well,
There'd be no reason for other acts.
If the acts were so similar that it was a signature, then I think 404B would apply.
Well, there's a lot more things than signature, right? I mean, there's a whole host of things in 404
Right.
and 2945, 59.
And I would respectfully submit to the court that none of those apply here.
Okay.
This is these are all, fairly straightforward, theft cases. There's nothing special about them. And again, the fact that it introduces confusion, we could, the state in their motion refer to the wrong alleged victim in one of them. I think we should try and avoid presenting this to the jury in this way. I think it adds confusion, and I don't think it adds any clarity.
All right. Is the state going to move to admit B? Exhibit B? Didn't you say Exhibit B, the interview?
I haven't labeled it yet. I can label it as
thought-
State's Exhibit 1.
Okay.
Okay.
Well, I mean, I think it's clearly, and Ms. Blake brought up the Jackson case where I permitted another drug trafficking allegation because it was what led the shooting victim in that case to come to Eastlake where the incident occurred. Otherwise there would have been and again, the word is context, no context as to why this person came from Detroit to Eastlake and there was a shootout. Okay, there had to be a reason behind it, and it's fair for the jury to see that reason. So certainly with regard to April, August, and the September 20, that aside from the 404B argument, there is, again, this did not, what did you say was September 11th is the date?
The date in
indictment?
question here.
September 7th, September 11th doesn't happen in a vacuum. Okay, there are things that lead up to that and actions taken by Vista Springs beyond what happened on that one date. So I think contextually it's valid that testimony be allowed in. And also under 404B, the facts and circumstances in 2945-59 also, I think clearly those fit within the purpose and the parameters of 404B and 2945-59. As to Vista's Tapestry, I think I need to take a look at your Exhibit 1 and treat that differently perhaps than the Vista Springs.
Your Honor, I would mark the defendant's interview, then we have it on a flash drive as State's Exhibit 1. I'd ask that it be admitted for the sole purposes of this hearing. And if the court would be inclined to listen to it, I think you'll hear that throughout, the defendant repeatedly refers to the Tapestry incident, and it's crucial to this case, telling the story of this case, and again, 404B as we've outlined.
Is there an objection to Exhibit 1?
No, thank you.
So it's admitted, then just give that to Kathy. Anything further? From the state,
No, Your Honor, thank
from the
you.
defense?
One housekeeping matter. Ms. Jurasek was arrested here in the hallway.
Oh, yeah.
Can she wear those same clothes?
Yeah, she's entitled to wear civilian clothes. and
Do we need an order to?
Do not need an order. The jail has a standing order that people are to wear their civilian clothes without having to file a motion and get permission to do that.
Okay, thank you, Your Honor.
Judge, one other quick thing, sorry. On the motion to determine admissibility of evidence with respect to the records from UH coming in, we also have the chain of custody, and we have a certified record of the chain of custody from when it got to Tri-Point and when it got sent off. I think it was like on September 13th that it got sent off. I would ask if the court's admitting the tox screen itself, the record of the tox screen, I would ask that we could also admit the chain of custody with it. Mr. Fatika referenced some things that might relate to chain of custody. The jury can see the whole record from UH with the chain of custody.
What is it, what do you have with regard to the chain of custody?
It's a record of when the urine arrived at Tri-Point. It's a record of the 4 people that at UH essentially, or Tri-Point, touched or came into contact with the urine. On September 12th, it's logged, at the time it's logged in. On September, I believe.
Is that part of the certification by UH?
It is a second certification. UH
Okay.
said, it took a little while for UH to get these records due to the changeover. They didn't have access to their old
All right, Mr.
management.
Fatika, as to that issue?
We don't have an objection, Your Honor.
All right.
Thank you, Judge.
All right, so we're set for Monday. We'll get you
Yeah, you can ask me.
the jury questionnaire is probably later on tomorrow as to the 45 that will be brought in, 36 in the court, and 9 fill-ins for any of the 36 that don't show.
Your Honor, may I?
Mr. Nasik?
May I please be just let out, I'm not a threat or a threat to run or abuse, or I won't do anything except for stay home. Can I have my,
Well, there was a very specific reason that the bond was revoked.
I
and
didn't
so
really
it's
know
gonna- it's
what
gonna
it even
remain-
was.
It's going to remain revoked.
All right.